After the Trump administration announced it would no longer separate families at the border, it is now attempting to bypass a court settlement that dictates how long children are detained. The so-called Flores Agreement dates back to 1997 and stipulates that children generally need to be released after 20 days. Newly proposed rules could extend that time frame in cases where children are in custody with a parent or legal guardian. To understand how the settlement originated and its impact on immigration policies, we turn to Shefali Milcherik Desai, faculty at the University of Arizona James E. Rogers College of Law. Tell me what the Flores Agreement really is. What does this mean?
So the Flores Agreement does two things. The first thing it does, it says, is that if there are minors, whether they're accompanied or unaccompanied minors, that go into government custody after they cross the border, then they have to be released without unnecessary delay. That's the language. And by the way, unnecessary delay has been construed by the courts to mean 20 days.
Okay.
Now, during the time that they are in custody, what the Flores Agreement requires is that they stay in licensed detention facilities, and that these facilities are non-secure. And let me explain what that means briefly. So a licensed facility has to be licensed by a state child welfare agency. And there was a reason for this. It was independent monitoring that was going to ensure the safety and security of these places. Non-secure means that these children would have access to the outside, to educational resources, to public places even, like parks. And here's why that part of the agreement is so important. Before the agreement, the conditions that many children were in required daily strip searches, body cavity searches. They were sometimes housed with adults who were non-family members. One of the plaintiffs in the original case actually was a 15-year-old girl who was daily strip searched and was held in a cell with only other adult males.
In 2014, we had a large number of unaccompanied minors, in some cases mothers with children, at the ports of entry who then ended up in custody of U.S. Border Patrol. We have footage from Nogales. Did this also meet that same criteria? Should those children have been released prior to the 20 days?
Under the Flores Agreement, all children, all minors, have to be treated in the way that I just described under the agreement. And that was reinforced in 2015 by a federal district court judge.
Has anyone tried to change it, including President Obama?
The Obama administration did try to change or come out from under the Flores Agreement in 2015, and that's the court case I was referring to. And this is contract law 101, basic contracts. The judge said, you haven't fulfilled your obligations under the contract, and you can't get out of the contract because the plain language is clear that you have to do these things. But more recently, what the government is doing is it's actually proposing new regulations. The Department of Homeland Security has proposed these regulations, and they will become law in 60 days, presumably. And what they're saying is we should, once again, be able to get out from under the Flores Agreement. And they're saying it for two kind of separate reasons. One reason is they're saying the state apparatus to license these detention facilities doesn't exist, and we need places to house families together in detention settings, and so we want to take over that process. The other thing that they're saying is we've complied with the Flores Agreement because of changes in the law, and so now we should be able to house minors beyond 20 days.
So we've had two different presidents, two administrations, one Democrat, one Republican, try to say this is just not feasible for the federal government. Where does it stand right now as is, given that we have this influx of families coming to the border?
Well, so what the government is saying is that we're stuck between a rock and a hard place. We can't separate families because we now have a court order telling us we can't do it, and public outrage. But we also can't house families in detention settings because we have the Flores Agreement standing in the way. But that's where this third alternative comes into play, and they're called family case management programs, and they were actually piloted by DHS in 2015. And under that particular program, the contractor stated there was 99% compliance with court orders after the family unit was released, and that included many families who were ultimately deported and complied with that order.
If a mother and her children are here in the United States and they're released by authorities and they have nowhere to go, does the federal government connect them with shelters or services?
Well, that's what the case management program does, yes.
Okay.
They get to live in as normal of a way as possible, but they also, somebody explains to them what their orders mean. And this is very important because I know the government will sometimes cite what they call in absentia numbers, percentages, which means someone didn't show up for their court hearing. Well, first of all, those numbers are misleading because the government only uses initial hearing numbers, not subsequent hearings or final determination hearings. Many people leave detention centers without a notice of hearing, or if they have it, it doesn't make any sense to them. It's written in English, no one explains it to them. They often move to a different state and their address isn't changed and no one's helping them to do that.
How feasible is it for the federal government to work with the state and create these environments where mom and kids are together? I mean, this can't be very affordable.
No, it's not affordable, not affordable at all. In fact, the figures that I've seen is that for a family of 4 to be in one of these detention facilities costs up to or more than $900 per day to the U.S. taxpayer. Meanwhile, there are alternative programs that have been proven to be not only more humane, but successful. And those programs cost on average about $36 a day for a family.
There are likely American taxpayers who are listening to you and saying, but at what point will we continue to fund this? And at what point are we not providing services for people in this country already?
Yes, and I think saving over $800 a day is a big start for folks who don't think that that's where our money should be going, because right now with the detention centers, we're spending far more than we need to. And then I want to come back to the legal access issue, because attorneys not only help people determine when they have valid claims and get them through that system as expeditiously as possible, but they also explain to folks when they don't have valid claims. And that's very valuable, I think. And the other thing that we can do is fund our immigration courts and make them independent so that we can do away with the backlog and also make sure that the laws are equitably enforced.
All right, Shefali, thank you.
Thank you very much for having me.